And with that, I'd like to welcome you to this session. We're lucky today to have a member of the Microsoft Security Response Center. Unfortunately, Alex and Maddie are not able to join us this morning, but we do have Chris Mills, and he's going to be discussing the law of unintended consequences, the GDPR on cybersecurity readiness and response. And I know many of you here in the room are feeling the effects of the GDPR already. It's probably one of the most influential privacy regulations of our decade and probably of our generation. And so today we want to go in a little deeper on how that's impacted us here at Microsoft and how it's impacting the community, the ECHO community that all of us are a part of. And Chris Mills is joining us today, as I said. He is a highly respected member of the Microsoft Security Response Center. He also interacts with the Cyber Defense Operations Center on a daily basis. Chris is the lead for our Software and Services Incident Response Plan. He responds to the high-severity product, service, privacy, and adversary incidents on the team. He also manages the Compromise Credentials program. How many of you in the room are involved with Compromise Credentials? Oh, nobody. Oh, in the back. Great. We're glad to have you here. So there's a lot the rest of you can learn from this session. Also, prior to Microsoft, Chris directed the Information Privacy Technology Program at the Depository of Trust and Clearing Corporation. He also was responsible for building the Navy Computer Forensics Lab while serving in the Navy. So with that, I'm going to turn it over to Chris. Thank you, Chris.
Hey, thanks, Monica. So who's ready to talk privacy law at 10 o'clock in the morning? So just want to take a look at the room. Who here is an incident responder? Okay, very good. How about a lawyer? Nobody? One? Okay. I need somebody to keep me honest with this. So in incident response, we all know that we need things. We need evidence to detect, to deter, to enforce against cyber attacks. It's data, it's evidence, and we need it from every log-generating device, every application, everything that a user does on our systems. We want to know about it. But the problem that me, from a perspective of an incident responder, is seeing is that this data is drying up. We're seeing that teams that manage applications and systems are deleting this data after a very short period of time, and the answer I get for why is because GDPR. And so we're going to work this out. We're going to figure out what to do. How can we move forward while keeping our things secure, at the same time respecting the privacy demands and needs of our customers and our users? So before I get into the content here, I want to say a couple words about my co-presenters that you may have noticed are not here with me on the stage today. Alex Harmon is an incident responder in our Cloud and Artificial Intelligence division. He works the really tough cases in Azure, the ones that nobody else can solve. And Maddie is an attorney specializing in privacy law, and she gives us responders the advice we need for doing the right thing. Due to circumstances beyond anybody's control, they were both unfortunately not able to make it to present with me today. They both spent countless hours with me working on this presentation, doing the research, coming up with the scenarios, and getting this nice deck put together. I would not be able to be standing here today without the help that they gave us. So a little bit of a disclaimer. I'm not a lawyer. I'm certainly not your lawyer. You probably heard that same line in the last session. But I'll do my best to cover the legal aspects of GDPR that are relevant to incident responders. And none of this information should be considered legal advice. And my advice to you is consult your attorneys in your area. So GDPR, the General Data Protection Regulation. This went into effect May 25th of 2018 for the European Union. for the protection of personal information of European citizens and those that are residing in the European Union. Why do you need to know this? Well, because with great power comes great responsibility. And as security responders, we need to comply with GDPR, and we need to help our organizations as a whole comply with GDPR while ensuring that we have the access to the information that we need to do our jobs, to investigate those incidents and to get to a good resolution. So we'll start by going over the basic tenets of GDPR. I'll try to get through that quickly so nobody falls asleep. Then we can put those in the context of incident response. So the four basic tenets, lawful, fairness, and transparency. What this means is we can only collect personal information that we have a legal right to collect. And we need to be fair about collecting it, meaning we can't collect information from one group of people and not collect it from another group of people. And we also need to be transparent and clearly communicate to the people giving us their data about how we're going to use it, how we're going to store it, process it, secure it, et cetera. The second tenet, doubled up there, is accuracy and integrity. So for accuracy, the data needs to be and stay accurate. And for integrity, we need to know that the data has not been altered or the sources are hidden. We need to know where the data has come from and whether it's been changed and who did that change. Next is confidentiality. The personal information needs to remain confidential. And purpose limitations. It requires that we only use personal data for the specific purposes that we told the users we were going to at the time we collected it. If anything changes, then we have to go through a different process to make sure that's all legal. Finally, data minimization is the biggest one that's affecting my job as an incident responder. And the requirement there is that only the data that's needed to provide a service is collected, used, and maintained. And so as responders, what do we need? Is it the same as what the system owners and developers need to operate their service? Probably not. And so data minimization becomes a really important thing for us as responders within the context of GDPR. Whenever you talk to a responder and you ask them, what do you need? My answer is everything. Give me everything you have and I'll figure out later whether I need it or not. It's nicer for me to have it and not need it than need it and not have it, because you can't go generate it after the fact. And so we'll go through some scenarios that will probably sound familiar to you, whether you're in Microsoft or from a guest that we've invited here. The three we're going to talk about are the web app compromise resulting in a data breach, a DMCA repeat infringer, and also an adversary stealing intellectual property from an organization. So to set this scenario up, a web app is compromised through a cross-site scripting attack. The attacker then pivots into a database system that houses customer data, and then the attacker exfiltrates gigs and gigs worth of data. And so as responders, what do we need to tell the story of this attack? And this is where GDPR will start to make things interesting. So in this scenario, as part of this, compliance says we need to mask the IP addresses in our logs because GDPR. An IP address is personal information, and we don't need that to operate the service, so we don't need to keep that in our logs. So let's say we have the IP address and we mask the last octet to .000 to protect end user identifiable information, because that's personal information under GDPR. So if we had that last octet of the IP address, we could locate the attacker, but with it masked, our investigation sort of stops on that end. I mean, we're still going to solve the problem, but attribution and finding out who to go after and who to take enforcement actions against becomes really, really difficult. So what do we know? We only know that a web app has been compromised, but we don't know who, and we don't really know where else to look on our network for activity from that same actor. We can't share that information with our threat intelligence teams for them to kind of build a profile of this attacker. We can't share it with the other Defender teams. So if this web app gets compromised in, let's say, our Azure service, we'd like to be able to share that attacker information with our Office team, with our internal security folks as well so that they can go hunting in their environment to try to find this same actor. That's all done. And so this leaves us really with nowhere else to go. The next scenario, which I haven't personally dealt with, but probably more lawyers have than incident responders, is repeat offenders to DMCA. So as an online service provider, we facilitate the hosting of content, and some of that content is uploaded by users that don't have the permission to do it. And so the DMCA has a system in place to file a complaint for a takedown notice. We process that, we take the content down, and we move on. There's a thing in DMCA called DMCA Safe Harbor, which outlines a few set of rules that we as a service provider need to comply with in order to stay out of legal trouble ourselves. And so I'm actually going to read this from the slide because a lawyer wrote it and I can't do a good job of summarizing that. So we must require to have a notice and takedown process to avoid contributory infringement liability for the copyright infringement actions of customers. That was definitely written by a lawyer. And so this includes our requirement to terminate the accounts of repeat infringers. And so where GDPR comes into this is, again, going back to the logs. We need to be able to understand who are those repeat infringers. And if we mask the email address in our logs, we won't be able to do that. And what that does, it puts us as Microsoft and as a service provider at legal risk, and we can be held accountable for the copyright infringement and get into a whole bunch of legal trouble for that. Last scenario I want to talk about here is stealing of intellectual property. And this is more of a Microsoft or a service provider focused scenario than the other two. And so looking at this within the context of Azure, we'll set this up where a customer is hosting on our platform. They're entrusting us to secure the platform and be able to help them with an investigation if something goes wrong on their end. So the customer has their Azure account compromised, and they lose a whole bunch of intellectual property that was stored on a server. The customer engages law enforcement because the IP is worth so much. They can get a criminal case out of this. So now law enforcement's engaged. They're moving at the speed of law enforcement, which means we're not going to see anything from that for, I don't know, a month or two. And so law enforcement submits a lawful order to Microsoft to produce this data. And we find that the IP address and the date and time sent to us are attributed to an internal subscription that somebody in the company owns. And so our first thought there is, well, we had an internal compromise of a subscription, and that's what's being used to attack the customer. Unfortunately, because of GDPR, all of those logs were deleted after 29 days. And it took about 40 days for the order from law enforcement to come in. And so the result there is that no definitive link can be made between the IP theft and the internal subscription that may have initiated that. We're not able to track it down. We're not able to fulfill that order. And greater than just that specific incident is this erodes trust in the cloud. Trust in Microsoft to do the right thing to protect customers, but trust in the cloud overall. It's not just Microsoft that has this problem. Google, Amazon. Every cloud hosting provider is going through this very same thing, and it's very important that we maintain this trust in the cloud so that we can continue our operations. So why is this happening? So the data minimization principles that affect how the services are engineered are all built around specific rights that the GDPR grants to citizens and residents of the EU. And so you'll see these referred to as data subject rights, or DSRs, which go into data subject rights requests. And there's a whole formal way to exercise these if you're a European citizen. And so the rights that we want to talk about are really needed to be known by all incident responders. And we need to know them up front so that we can have a clearly articulated response to those whenever they're exercised. And we can prepare ourselves for these requests when they come in, and we're not scrambling at the last minute. And so we need to both respect these rights, and we also need to be able to gather and analyze and store the information necessary to do our jobs, to conduct these investigations, to understand what's going on. And so we're trying to balance privacy and security. It's not a conversation of privacy or security. We have to have both in order to be effective. And so we need to know what these data subject rights are and what they are not. The first one is the right to rectification. And what this means is that individuals have the right to ask us to update the information that we have stored about them. If their address changes, if any data about them changes, they have the right to ask us to update that for them, and we are obligated to do so. Next is right to be informed. This is a very important one, especially for privacy advocates. We need to inform our users of how we're using their data, how we're processing it. And building on that is the right to access. Customers, users, European citizens of our services need to be able to access their data whenever they want, and we need to provide that access to them. Next is right to data portability. You may also have heard this referred to as right to export. And so this is so somebody can come to Microsoft and say, hey, I want every single thing that you have about me put into a structured format that I can download and go take it somewhere else or take it into my own system and use it myself. Next is right to erasure, also known as the right to be forgotten. This is really the one that a lot of people are focusing on when it comes to redacting data and deleting logs. We'll get into this one a little more. Individuals can request either verbally or in writing that the data about them be deleted, and we've got 30 days to respond to that request and get that data out of there. Next is right to object. This is a right that the users have to tell us they don't want our data to be used for a specific purpose, and we have to honor those. And last is the right to restrict processing, very similar to the last one about having us not process their data anymore. It's things that are not included in this. Data subjects do not have the right to hide evidence of a crime. You can't commit a bad act on our services and then file a GDPR request to have us delete those logs and hide that evidence. We're not going to do that. There is no right to disrupt business operations. And so if we have a legitimate interest to have this data to continue operating our services, we don't want a data subject rights request to come in and have that data and possibly disrupt our services. And the last is there is no right to prevent legal or regulatory compliance. If things are on legal hold or if we're holding data for a specific investigation, we can deny those requests that come in and ask that to be deleted. So the first myth in GDPR is if I delete my data in 29 days, then I don't have to comply with GDPR. I've heard this a lot from all around the company about the easy way out of GDPR is just don't store the data. And this is not true. It only really alleviates one data subject rights, and that's the right for deletion. All those that we just talked about are still applicable to that data. And so deleting the data really doesn't solve GDPR, but what it does, it really complicates me as an incident responder. So GDPR requires us to execute the right to be forgotten within 30 days, and we can do that. But again, we'll take a look here of what it actually does. So as a controller, and I'll get into the differences between controllers and processors here in a second, the green check is all that it does. And so from Microsoft's position as a data controller, we're not really helping ourselves out by deleting the data. And so what is a data controller? What is a processor? And so per the regulation, so this is Article 4 of the GDPR, which goes out and lists all the definitions. And so if you haven't read the full text of the GDPR, it's 88 pages. It's a thriller. I recommend that you go pick up a copy and take a look. But really, Article 4, if you don't read anything else, it's really good to get familiar with what all of these terms mean. It's a very short section, just kind of a glossary format. And so as a controller, we are the natural or legal person, public authority, agency, or other body, alone or jointly with others, determines the purposes and means of processing personal data. And what this means simply is the data controller is the one who decides what happens to the data. They decide how it's collected, how it's used, how it's stored, how it's processed, and when to get rid of that data. On the other side of things are data processors. And so we at Microsoft fill both of these roles. A data processor simply put, processes the data at the specific direction of the data controller. And so when we're looking at Microsoft, we can see ourselves as the data controller for the direct interaction with users that we have. So somebody that has an account on a Microsoft system, we are collecting the data that we need from them to operate the system. We are deciding what to collect, and so in that case, we are the data controller. Now, if we look at our services side of things, let's take SharePoint Online for an example. So we sell SharePoint Online to a customer, and the customer's customers or our customer's employees use that service to put their data. So our direct customer with the SharePoint subscription is determining what data they're collecting, how they're going to use that data, how they're going to process it, store it, and how long they're going to keep it. So in that scenario, our customer is the data controller, and we as Microsoft operating the SharePoint service is the data processor. And diving in even more for a specific Microsoft example, this kind of shows the same thing where this is a direct screenshot out of the Microsoft Enterprise Online Services Taxonomy document. I'm going to talk a little bit about that more here in a second. And in the roles here we discussed, the little person with MS is us as Microsoft. We are the data processor. Our customers, we'll call them C1. They are the license holder for, let's say, Azure. They're the ones logging into the Azure portal. They're the ones spinning up a VM. They're creating the services that they're going to build on top of and give access to their customers, which we're going to call C2. So a customer one comes in, they spin up a VM, they install a web service on it, they build a website, and now they market that website to their customers, to the C2s. And so in the C2, they are a data subject. They're the ones giving their data to our customer, C1, who in that case is the data controller. And we are processing that data at their direction, and we have some obligations in that piece as well. Second myth, anything that might be personal information must be personal information. And this is something that I've seen personally as well in all of the months and months of preparation that we've done to prepare for GDPR. We take the approach of, it's all personal data, delete it all, we don't need it. But that's not true, and also that's not good for us as responders. And so personal data is any information relating to an identified or identifiable natural person, and that's key. It has to be a real human being, not a company, not another entity, but a real human being. And an identifiable natural person is somebody that can be identified directly or indirectly by reference to an identifier such as a name or an identification number, location data, an online identifier such as an IP address, and one or more factors to physical, psychological, genetic, mental, economic, cultural, or social identity of that natural person. It could include any or all of things like names, addresses, telephone numbers, email addresses, usernames, all that stuff. Things that we may not typically think of are things like IP addresses, where an IP address in combination with those other pieces of data now become personal data. We have to protect it, but at the same time, we also need to preserve it for our investigations. Personal data for incident responders, we need to collect it to meet our security obligations. And so we're not just providing a service, we're providing a secure service. And that requires us to have certain pieces of data for us to investigate things that go wrong on the service. And also, as part of the privacy requirements, when there is an issue on the service, we have notification requirements. And we also have to be able to know who to notify, and we have to give a good enough notification so that the data subjects can take appropriate action to protect themselves. And back to, are we a controller or a processor? We are both. So I mentioned the agreed upon taxonomy. This is a very Microsoft specific thing, but I encourage the guests that are here with us to go back and talk to your organizations about defining a way to understand what is the data, what is personal data, what are our obligations surrounding each of those types of data elements, and what do we really need to preserve to be effective in our incident response. Another myth. There are no exceptions to GDPR. And this is a half-truth. We don't need exceptions, but what we do need is what's called a legitimate interest. And so GDPR Article 6 defines what those are. And do responders need personal information? Yes, we do. We need logs, even more logs. We want packet captures. We want crash dumps. We want memory dumps of VMs. And strictly looking at GDPR, we can't keep that until we pull off the covers a little bit and see that, yeah, we really do need that. And that gives us what's called the legitimate interest to retain that data. And so the legitimate interest can cover a lot of teams when the data is used for a common purpose. And that gives us the legal right to reject certain data subject rights requests, the biggest one being the right to be forgotten or the right to erasure. So going back to that first hypothetical scenario where the web application was compromised and it resulted in a data breach, just to recap that, cross-site scripting attack compromised the web app. Attacker was able to get into the database. They were able to exfiltrate a bunch of data. So what is the personal information that we have in this scenario that we need to retain? So we know who the customer is. We know the IP address of the web application that's running on our services. That's easy to keep. The other customer information about third parties belonging to the customer, this is where it gets a little tricky, because we may not think that we need to keep this, but in order to adequately investigate the issue, we certainly do. And the logs from the web server that recorded the evidence of the exfiltration of data. And so we need this information to know who's been affected. We can take that IP address from the attacker and pivot it to look at the other customers. Maybe this is not the only customer that's been affected, but maybe it's the only one that's noticed it. And so that helps us be proactive with our customers and be on top of things and go that way. We can also use it to determine other affected assets. Are they only going after this one particular service that we're hosting, or are there other things that we need to be concerned about? We also need to identify which data was accessed and identify the total scope of the exfiltrated data. And so deleting the IP address or masking the IP address may be really the only key thing that you can pivot on in an access log to understand which events are correlated together. And so looking at that in the maxed IP address, we may not be able to understand how much data was actually taken out. And finally, we want to be able to identify the attacker. And this is not only useful for the operational teams and the security teams defending the service, it's also very useful for our threat intelligence teams to build that profile so we can be more proactive at stopping things in the future. So we need to analyze our legitimate interest. They have to be weighed against the fundamental rights and freedoms of the data subject. However, there is no fundamental right to be free to commit crimes anonymously. You could take a look at this as a physical crime. A bank robber in a mask has no fundamental right to be masked. So once you're doing something unlawfully in our system, you really throw away that right to remain anonymous. And so it is possible for us as incident responders and investigators who have a need to collect and retain and preserve and keep confidential this personal data that's necessary to identify, investigate, analyze, monitor, and respond to and resolve these incidents. That gives us the legitimate interest we need to preserve this data. But open-ended exceptions to this are not allowed. And in particular, Article 6 of GDPR, which really defines what a legitimate interest is, it states that open-ended exceptions should be avoided at all costs. And an open-ended exception means we can keep all of the data forever. And that's really hard to defend because we can't articulate why we need that data and for how long we need it. And so we need to do this legitimate interest analysis, kind of partnering with the legal team and partnering with the defender teams that are around the country. And it needs to be implemented in a manner designed to respect the rights of the data subjects while still preserving what we need to do as incident responders. And so GDPR compliance is never an excuse to avoid securing your system. I've heard this many times from many different teams. We can't do it because GDPR. And they can't do it because they didn't do the research they needed to do to get it done correctly. And so incident responders and analysts need some of that data that's being redacted, but we need to keep it in a secure way so that it's only used for the purposes that we define within our legitimate interest. And so we've seen real security investigations here at Microsoft hit a wall because we can't go any further because the data is gone or redacted. So operationally, we have at Microsoft and what you may have at your own companies called variants. And so a variant is a way for us to formally document our legitimate interest in retaining this data and denying the data subject rights requests. And this is what we use to back ourselves up if we ever get challenged on it. There is not an official way to file an exception with the GDPR Commission, but we do have a way to document our legitimate interests so we can defend ourselves later on. And so here at Microsoft, we have a variant that allows us to keep this data and deny these data subject rights requests, and it applies across all of our services and engineering teams, our Office group, our Cloud and Artificial Intelligence group, our Research group, and our Windows group. And so if you at Microsoft are being told that you must delete your data, go dig a little further because you probably don't have to. So this variant covers our security logs, telemetry, crash dumps, disk images, memory dumps, things like that. And it allows us to keep those for a certain period of time to facilitate our investigations. And when we did our legitimate interest analysis between us as responders and our lawyers working on the GDPR, we agreed upon 3 years as a reasonable amount of time to retain this. And so 3 years means from the time we collect that piece of information, the clock starts ticking for 3 years, and after that, we automatically purge that data. It's about, the number has gone down, which is good, but the average used to be 90 days from the time that an attacker is on your system to before it's discovered. And so if you're deleting data in a short period of time, you're not going to have the information you need to investigate. In addition to the retention, this variant allows us to deny certain data subject rights requests. So a data subject cannot come to us and say, delete the security logs that have my information. They also can't come and say, I want you to alter the security logs, which could potentially allow them to cover up their wrongdoing on our system. So the call to action that I have here is ask questions. Ask questions to your engineers, ask questions to other responders in your group. Talk to your lawyers, talk to your privacy reps, understand what your specific obligations and situation call for. Get everything documented ahead of time so you're covered whenever you have an incident going on. Understand what you might be missing. You may already find that certain groups are deleting things out of your data sets. They're masking things. They're removing email addresses or IP addresses. Run some tabletops, run some drills. Go through this. Understand what's the data that you need to respond to an incident. See what's actually missing, and then go from there to correct that. Also, evangelize the need for data retention. If you're here at Microsoft, show them the variant documentation. There's an internal site under privacy that links to all of these things. You can get more information about it there. Let them see in writing that they can and should keep this data for you. And the last piece may cost you some time, and it'll probably certainly cost you money. And considering the number of systems that your company has and the amount of logs that they're generating, some security groups and engineering groups may not be willing or able to retain that data for you. Their systems aren't designed for that long-term retention, and GDPR is now a nice and easy excuse for them to say why they can't retain it for you. So you may have to build a system, build a data warehouse, keep this information secure, make sure it's only accessed by the people that need it for their job to perform their duties as security investigators. So you keep that legitimate interest. The data is only used for that specific purpose and for nothing else. That's what I have for you. I'd like to open it up for questions.
Morning. My question is can you comment on a situation where we were taken to court and we were able to successfully defend our variances against the DSR, or has that not happened yet?
So GDPR is so new, I am not aware of any entity actually being taken to court yet on defending the denial of these certain data subject rights.
So in your first example, you mentioned that, or in the first example, the law enforcement came in after 40 days. What would happen if an attacker attacked and then requested to be forgotten? Nothing has been opened yet internally to say, hey, we have an incident here, we have to keep that data. Wouldn't we then just delete that data and then 10 days later, the law enforcement comes in and we say, well, they were asked to be forgotten and we have no way to track it back?
And that's a very important part of those variants that we discussed, which allows us to deny those requests for security data. Without those variants, we have an automated system at Microsoft that users can come in and exercise their data subject rights. And it's not limited to European citizens. So at Microsoft, we build it so that these data subjects rights apply equally across the board to any citizen of any country, no matter where you are. So you can, if you haven't, take an opportunity to check out the rights that you have as a data subject. If you visit account.microsoft.com/privacy, that's going to give you a whole dashboard that you can go in there and you can request your data, you can request to be forgotten. And so really it wouldn't tip their hand as an attacker if they come in and request their stuff to be deleted. We've got 1 billion users. There's so many things coming in, it's just going to slip right under the radar. It's not going to kind of bubble them up as a potential adversary. So without these DSRs, without these variants to reject these DSRs, that data would have been deleted at the attacker's request.
Hi. My question is regarding the myth about deleting the data in 30 days. So, like in all the big companies, like in Microsoft, even you are as a service collecting the data and you are GDPR compliant and you are providing all the rights, but there are many back services like reporting, data platform team would be collecting data from you. So if they do deletion within 30 days, are they GDPR compliant because the main collector of the data is GDPR compliant?
No, so just simply deleting the data before the 30 days does not make you GDPR compliant. Really, the only thing where data deletion will help you is for transient data, and that means data that's being held for 48 hours or less. Anything else, you still have to respect all of those other data subject rights. So deleting the data is not going to help you there.
Hi. So this is more of a comment and to get your thoughts on if you've asked if you've had a similar experience, but different regions have different regulatory requirements and time limits and things like that. Mm-hmm. So we've, my experience, we've dealt with a part of the business who perhaps jumped the gun a little bit under the fear of GDPR and went to regulators when, in hindsight, they didn't need to. So the notification actually increased the risk to the business as part of their response. Have you come across that, or are you thinking about that?
So you're saying increased risk because the data's been deleted?
No, just exposing the fact that there's been an incident, risking reputation to the organisation needlessly, putting it out there. Some of these regulatory bodies, once it gets to them, it's public. The information is publicly available that an incident has occurred. Is that something you've come across?
So you're talking the statutory reporting to the data protection officers?
Yes.
Okay. Well, it is what it is, and from my perspective, transparency is key to this. And if we do have an issue with our data, I'd like us to be upfront and open with our users and get that reported out in accordance with the laws and regulations. Personally, I don't see that as a hit. It's really a learning opportunity, and you get better based on that. I'm not sure if I'm answering the question.
Yeah, I guess I've not framed it properly. But I mean, we don't go public with every single incident. But because the GDPR perhaps not understanding the requirements correctly, mm-hmm. parts of the business are being a bit knee-jerk reaction.
Okay, are you talking about reporting an incident to a governing body when it may not be necessary to do so?
Yes.
Okay, yeah, so that one is a good question to ask. So in GDPR, there are specific requirements for what constitutes a reportable incident to the governing body. There has to be demonstrable harm caused to the data subject, either financial or identity theft, things like that. And so if it's a contained incident where there is no actual harm to the data subject, it may not be reportable to the governing body or to the data subject itself. Mm-hmm. But it depends on the situation, and absolutely consult your attorneys before making a decision there.
Buttons pressed. Testing. Hey, so I'm a colleague of Chris's. I actually had a comment about a previous question about customer, basically an adversary calling in and requesting to have their data deleted before an investigation even takes place. As part of the authorized use clause, we can actually, you cannot request to have security logs deleted about you. So as part of the right to be forgotten request that would come in, the security logs would not have been part of the information that had been deleted about that particular adversary. And so the adversary may come in and request to be deleted, and we would delete, I don't know, marketing data, things where we have informed the user we've had proper consent. However, the security logs attributing their actions on a particular system at a particular time for use of an investigation would persist even beyond that deletion request. That is something we are allowed to do, and that is something we would continue doing.
And we're allowed to do that because of all the work that we've done ahead of time, working with our legal team and working with the responders to establish our legitimate interest to keep that.
Thanks for this talk. This was very useful. Just a clarification question. If you have collected the data and kept it available only for the variants, that is the incident responders and others, mm-hmm. As long as you have access control properly established on that part of the data for incident responders, are you implying that you can keep that data for 3 years and not delete it even when asked?
That is correct. So we can keep it for the 3 years. We can deny any request to delete it. But the thing is, it can only be used for the purpose of investigating security events. We can't pass that data off to marketing or to any other teams.
Exactly. Okay. Thank you. Thanks.
Hello. This is probably a pretty naive question, but as terms of service, could a company ask that a EU customer forgoes their GDPR rights in order to use their service that they're providing?
That's a good question that I'm not qualified to answer. That's more for an attorney.
Hi, this is very informative. I'm just learning about GDPR, and it's really informative. So I don't know if this is out of scope of the talk, but I was just wondering if you could talk a little bit about how it works for the countries that do not have GDPR. I believe you said it is for European countries, and how it functioned before GDPR came into existence.
Okay, sure. So I'll talk about what we're doing today. And so we took the GDPR requirements, and it's really tough to separate out who's European citizens, who's coming from a European IP address. And so we're going to take all of those rights, all of the restrictions that we have on processing and collection of data, and apply that equally. So you take the most restrictive set and you work from that. And so we don't have to treat different customers differently based on where they're from. Before GDPR, it was really up to the companies for whatever they wanted to do. So they could write their terms of use, they could give the notice of how they're going to use the data, and it would be up to the users to read that and understand it, and then make a decision themselves on whether or not to use that service.
Hi. There is any reporting method available for security operation where we can generate a report and see where we stand in terms of GDPR compliance?
So you're talking as an internal team at Microsoft, how do you check on, I guess, the GDPR health of your service?
Yeah, so basically any SOC operation or maybe CDOC itself can generate a report and see where we stand in terms of GDPR compliance report. So I'm referring to other compliance systems like PCI have some set of standard reporting that you can generate and see where you stand in terms of compliance. There is anything similar on GDPR?
So I can only really speak for C&AI, Cloud and Artificial Intelligence, which is the division that I work in. But for us, yes, we do have lots of reporting surrounding that. There are the tasks and the milestones are tracked. They're reported on. They're put into a wonderful Power BI dashboard that you can drill down and see, even down to the service level. So going into a little bit more Microsoft specific, every service that we have in here is registered into a system called Service Tree. And based on that, you can spread out from that and understand, is it compliant with certain things? What do we need to do? What's still left to be done? What's the data? What are the variants that apply to it? And so, yeah, as an internal service, we can see how we are doing with our GDPR compliance. Does that answer it? No? Okay.
So we've talked about how the variance allows us to keep data for security purposes. So I kind of have two follow-up questions to that.
Sure.
First, how do we define security logs? Because, for example, in Windows, we have massive amounts of telemetry that's coming back. Certainly on my team today, we're just treating it all as personal data, deleting it when requests come in, et cetera. So I guess where do we draw that line for security logs? And then I think the important follow-up to that is what infrastructure exists? Because as came up in an earlier question, we have to keep the data only for security purposes if we're using that variant. So
right.
What infrastructure exists that, let's say we decide these logs, okay, these are important security logs, we need to keep them. How do we do that in such a way that we ensure they're only being used for security, separate from our standard data usage pipelines?
Sure. So two questions. The first one about what do we need to keep, what's considered a security log. And this goes back to having a conversation with your system owners, with your lawyers, and with your security teams, and really running through a tabletop exercise to see what do I really need to resolve this incident will help you define those. And every service is going to be different. There's different log generating mechanisms. I mean, certainly Windows is common, but application-specific logs, maybe there's different logs from each type of application. So there's really no good, easy answer other than sit down, have a collaborative discussion, and figure out what you need. For the second piece is how do you securely store those logs? Again, that's going to be another discussion within each of the different areas of the company. And so in C and AI, we are developing a data warehouse to store all of these things, make sure that they're accessible to the incident responders, but then also audit that to make sure that the data is not being used for any other purpose. All right, and it looks like I am out of time. I'll be here all week if anybody has any other questions. If you want to send me an email, I'm christopher.mills@microsoft.com, or you can send me a message on Twitter at @thechrisam. Thank you, everybody.